Good morning, Mr. Chair and members. Thank you very much for allowing me to present on Assembly Bill 2943 to clarify that conversion therapy is a fraudulent practice under the Consumer Legal Remedies Act. I appreciate the opportunity to present this bill. As you have seen in the analysis and as well stated and well known, fraudulent practices with respect to something like conversion therapy is something that we would articulate and argue and suggest to you. In fact, the American Psychiatric Association, the American Psychological Association, the American Counseling Association, the National Association of Social Workers, the American Medical Association all also believe that conversion therapy does not work. And there is no evidence to suggest that it does work, and in fact, it does significant harm to one's mental health.
Morning.
Mr. Chairman, members of the committee, good morning. My name is Kevin Snyder with Pacific Justice Institute Center for Public Policy, where I serve as Chief Counsel. I address briefly the legal discussion in the bill's analysis. This bill differs significantly from the law banning sexual orientation change efforts, or SOCH, for those under 18. Two cases challenged that law under free speech and free exercise of religion. In Pickup versus Brown and Welch versus Brown, the court held that a prohibition on SOCH for persons under 18 survived these challenges because the law was narrowly focused on a regulation of professional conduct. But the Ninth Circuit found that even licensed professionals could communicate with the public about SOCH. In contrast, this bill prohibits SOCH advertisements by all persons. Further, the court found that licensed professionals could continue to recommend SOCH to patients and could administer SOCH to adults and refer minors to unlicensed counselors or religious leaders. Yet under this bill, all of those First Amendment rights are swept away.
Thank you. Next witness, please.
Hi, thank you, Assembly members, for your time. My name is Ken Williams, and I'm here today because I don't want LGBTQ people to have any rights taken away from them. I believe they deserve every option to pursue happiness the way they determine it. And this bill, which ought to protect them, I believe would actually rip away some inalienable rights to pursue happiness. I was confused about my gender, like the gentleman mentioned before, that they had some confusion and were on a journey to find themselves sexually. I can relate to them, and I can feel that pain. I didn't fit in with the boys or the girls ever in my childhood. And when my sexual desires emerged, they were only for men, and that was really devastating for me. It was very confusing. And at 17, I crashed emotionally, and I was contemplating suicide on a daily basis for a long time. I told my parents finally. I broke down. We cried together. They said they'd love me no matter what, and they asked me how they could help. We found a therapist who would help me pursue my option, which I wanted change. I wanted to live as a man heterosexually, and I devoured the few books and resources that were available. I devoured them, and I joined a group. And some of us experienced the changes that we were looking for in that group. Not everyone did. Despite years of homosexual identity and behavior, my sexual desires did change. I'm no longer sexually attracted to men. And I met a girl and fell in love with her, was sexually aroused by her, and I married her in 2006. Some do want to live out their same-sex desires, and that is their right. But not everyone who finds himself with same-sex desires is wanting to pursue that, is at peace with that. And so I'm trying to figure out why anyone would want to take away the rights of my people group, which is people finding themselves with desires that they would like to see change.
My name is Elizabeth Wanning. Sorry, I'm coming up at the last minute, so I'm speaking to you all completely spontaneously. I haven't had any time to prepare. I grew up believing that I didn't fit in with the girls. I didn't accept my life as a girl. I identified as a dyke. I had my first relationship with a woman. It began at 16. I came out in my early 20s. I lived locally here in Midtown in the gay community all through my 20s. I went to seminary, in a Presbyterian seminary in Chicago, Illinois. Openly gay. I was one of maybe 6 who were openly out and proud. When I graduated from seminary, I did ministry in the gay community, but my faith journey led me out of that lifestyle. As I pursued the Lord, I gained freedom. I eventually got married to a man, and I do ministry among other women who've had the same experience as me. I'm concerned that there is not enough reflective scientific study on the fluidity of sexuality for women specifically, and that this bill realized that many women seek refuge from misogyny and sexism in the arms of another woman. And this bill could hinder that experience of freedom and health, wholeness to women if it's passed. Please oppose this bill.
Thank you. Fletcher.
I'm going to support this bill, obviously, today. It's a great bill. I just want a clarification on the retreat aspect. If a church held a retreat, and parishioners normally in a retreat do have to pay for their regular costs. If it's an overnight retreat, if you go to marriage retreat, you do this as well. Would that be prohibited if the retreat dealt with issues of sexuality?
Good morning. Anthony Sampson with Arnold and Porter. So because this is different than the Ted Lieu bill that we saw, SB 1172, which was in the Business and Professions Code, which sort of created this outright ban for minors for purposes of sexual orientation change efforts. This falls under the Consumer Legal Remedies Act. So in the situation you provided, there would have to be that underlying transaction to have occurred. So to go to that retreat, first, that threshold issue of what their payment, right? And then the second question is, would the definition in the bill pertains to practices. So would that that conference wherein individuals were speaking, would they be practicing? And then, of course, there is this line between when do you enter into this world of sexual orientation change efforts, which is clearly defined in the bill, and we've seen courts uphold that language. When do you sort of cross that line into seeking to change one's sexual orientation? And I think at conferences where individuals are just speaking about sexual orientation change efforts and the fact that this exists and give their opinions on it and being very supportive of it, that's just them exercising their free speech rights. It's the moment that you cross into that territory and you are seeking to change their sexual orientation where, again, that's where you sort of cross the threshold in this bill. But again, the issue, again, would come, you'd have to ask a couple of questions before you even get there, which is, has that transaction occurred? Was that transaction solely for the purpose of attending a conference that's, sole focus was on sexual orientation change efforts? Are there multiple sessions on multiple different issues? And again, was that them actually practicing because the term in the bill is practicing, and so whether that constitutes a practice in a conference setting versus practicing within a church or within a medical facility.
I think I'm not clear. You actually caused me much concern. So, someone Catholic. I mean, I don't know what else we only have our own basis, right? So you go on a retreat with the church, right? If you want to get married or couples retreats, there's the church may bring people in. Would a church under this bill still, if you're paying simply for your overnight stay, and the church has a program by which people are voluntarily entering and we'll make it as simple as possible. The church brings somebody in who does in fact sit around a campfire and pray for your change of sexual orientation. Would that be illegal under this bill?
Likely not, because if the payment is for the overnight stay and the services are being offered to the participants at no cost, then this bill would not apply. So the Lieu bill that we saw was, again, just an outright prohibition, whereas this, you have to pay for the services being rendered.
Does this go to appropriations? I'm sorry. I'm not sure I fully understand or feel fully comfortable. I do think I'm comfortable with this idea when we're talking about business practices and this is fraudulent. I'm getting concerned when we're talking about, I don't even want to say normal because it could span a wide variety of religious activities that I don't think we want to, I can't imagine we're trying to step there. That creates additional problems. So I just would like to continue to work with the author's office just to ensure that we can explore all the possibilities of how this could be prohibiting a religious institution from practicing their religion, basically. Whether we believe that to be valid or true or good, which I personally don't think that, but I think we need to be careful, that's all. So if the author, I'm gonna of course support this, but the author is willing, since you don't have to come to my committee, but willing to come talk to me through the protections for normal religious activity, if that's okay.
Other questions, comments? All right, seeing none, Mr. Lowe, you may close.
Thank you very much. With respect, I acknowledge that this specifically is very narrow in scope under focused on this transactions under the Consumer Legal Remedies Act, and will still stay committed and will state that it is not the intent to go after religion or to churches, but rather this fraudulent practice itself. And so reiterating that notion, in the previous conversation, as it has passed the Consumer Protection and Privacy Committee with bipartisan support, this was similarly a conversation that one of our other fellow colleagues who was an attorney herself also raised. But that she was satisfied with that conversation with respect to this being very narrow in scope on these transactions. Finally, let me just hit to the notion of this concept of conversion therapy. This bill is an LGBT caucus priority of all 8 LGBT legislators in the state of California. And this notion of conversion therapy in itself, as if there is something wrong, then there's something inherently wrong. So aside from the fact, yes, we are in Assembly Judiciary Committee to talk about the specifics, and I hopefully feel that we have addressed those concerns. But this notion of conversion therapy, that we're somehow, there's something inherently wrong with us, is antithetical to my existence and to our colleagues' existence. Similarly, as you ask yourself that same question, can you be converted from whatever your sexual orientation is or your identity is? And I would suggest to you that the answer is no, and that I am equally proud of how you were born. I'm equally as proud as you stand. We in the state of California hope to demonstrate that we are a state of inclusion versus exclusion, and that we should just simply with love. And so I respectfully ask for a vote in supporting and leading with love.
Thank you.
I feel excluded.
So the motion is due pass. We do have a motion and a second. Call the roll, please.
Stone?
Aye.
Stone, aye. Cunningham? Chow? Chow, aye. Chu? Chu, aye. Gonzalez Fletcher? Gonzalez Fletcher, aye. Holden? Holden, aye. Kalra? Kalra, aye. Kylie? Mainshine? Mainshine, aye. Reyes? Reyes, aye.
That bill is out. We do have an